All right, guys, it's 11:57. We're going to start 12 o'clock. So I'm going to wait until 12 o'clock so that everybody officially signed in. I always like to go up a little bit earlier. And in the back, we've got Steph Pieterse, and on the other side of the building, we have Merlin September that is assisting me, seeing that everything I do right. And I don't muck around. All right, so we're going to wait for 12 o'clock. Then I'll announce myself, and we can start with advanced drafting skills for contracts today, tomorrow, and next week again. We're going to have some fun. So get a cup of tea, shift closer, and then on the dot 12 o'clock, we'll go through the house rules and so on, and we'll take it from there. Having fun. One thing about me is I never do anything I don't enjoy. That's just me. If I don't enjoy something, I don't do it, because it's like unacceptable for me. If you don't enjoy something, then you cannot do your utmost best in it. And of course, sometimes we do have to do things we don't enjoy, and then the word endear comes to mind there. All right, it's 11:59. A couple of seconds here from Sunnyside, Unisa. From 12 o'clock to 2 o'clock, and maybe a little bit over into that half an hour for today's session. There's a specific amount of work I want to do today in advanced contracts. I hope all of you have done the basic contract draft, because then chapter 1 will be easy for you. But there's always people that skip the basic drafting of contracts, senior people, senior colleagues of mine. And then, of course, they go to advanced again. So the first chapter, we just go over what's a whole book on basic drafting. So I'm happy to be here. It's always enjoyable. We are up the 2nd, the 3rd, the 9th, and the 10th. Oh, so it's a week after next week, I presume, or something like that. I'm not sure. All right, it's 12 o'clock. We've got to start. We've got a lot of work that's ahead of us in terms of this. So let's start. First of all, we're going to do the house rules. Important, they say important on house rules. I think you can see it maybe there on your screens, maybe not. For certificate purposes, announce your attendance for all sessions. There is 4 sessions here, so every time you must announce in the chat function so that Merlin September is present, and they can see that you are here for the 4 sessions. You are listening to what we are saying to you, and that makes you then susceptible to receiving that certificate. Ensure your microphone is muted and your camera is turned off throughout a webinar. There's many reasons for that: communication reasons, etc., data reasons, etc., So ensure your microphone is muted, your camera is turned off throughout a webinar, otherwise it's a disturbance. Lead might record a webinar for Q&A purposes. According to company policy, copyright protection recordings will not be made available after the webinar. It is therefore suggested that you take notes, electronic notes, physical notes, like in old times, and so on. Questions will be addressed at the latest after the last and final session of the 4th session webinar via email. All questions must be typed using the chat function. Let me explain this to you, that you can ask subject related questions. You cannot ask questions beyond this. And by the 17th of this month, I will reply to all questions in a document. The reason for that is I research your questions. I don't shoot out of the hip like a cowboy. I don't have to prove myself to anybody. My name is James Clark. Let me introduce myself quickly. I suppose I should have done it at the beginning. I'm a practicing advocate, and I have a doctoral in divinity, subdivisional from theology. That's me. So I don't shoot out of the hip, and I don't have to prove in terms of my titles myself to anybody, and therefore I take my time to answer your questions. I want to say something here, and then later it's wrong, and I've led you down the wrong path. So that is important for me to look at. I just have a note that arrived here. Yes, and of course, like we said, we've already announced it, but we have to say it again. Please, guys, you have to put off your cameras. You have to put off your cameras. That's number 2 there, and that's very important. So Steph Pieterse just ran in here, gave me that note because they can monitor it in some way. please put it off there. So by the 17th, all your answers will be, your questions will be answered. In terms of that, might I just ask, please, guys, I'm a practicing advocate. I do civil work, I do criminal work, and you cannot ask me to draft your opinion under this training on a case you're doing. If you want to do that, you must instruct me properly. And if you instruct me properly, then of course I will assist you. I will assist you in drafting a complicated contract for you. I can do that for you. But I see you, especially with the last one we did, in terms of basic drafting, etc., etc. People were so excited. They wanted me to solve their problems. And remember, the same as you, I'm a practicing advocate. All right, so your questions must be subject related. I will answer them. We'll answer them fully. I make an effort with them. I throw court cases in there. I try to show you everything because I enjoy this. I enjoy drafting contracts. I enjoy drafting pleadings. I enjoy drafting anything pertaining to criminal work, from the representations to the pleadings, everything, affidavits, everything you can imagine. I just finished a big fraud case investigation. I did for that we handed over to the SAPS, a finished investigation of over 2,000 pages. I love this kind of thing. So if you ask me something, keep it subject related. And remember, I'm also a practitioner like you. All right, that's good then. So let's have fun. The last thing is we welcome you. Obviously, we welcome you. Post all your questions in the chat function. Mil and September will accumulate them and they will come to me. And by the 17th, we will then give you feedback. And I enjoy your questions because remember, I have a policy in my chambers that we learn from each other. It's not to say that I'm sitting here, I'm the presenter. That by no means means that I know everything. All right, it's 4 minutes past 12, and I think we should now stop with that. Let me just see if I can do the right thing here. I need to now quickly go over, and I did it. Well, I'm impressed. I'm a dinosaur when it comes to electronics, and I was able to do it. Let's scroll down electronically on your screen, there to page 3. That's your outcomes. You'll see there that this is what we expect in your outcomes. You will be able to do when we are finished here. If you scroll further to chapter 1, that's on page 4. You'll see there's the introduction. And if I can summarize the introduction, basically we're just saying to you something that's very true. Your whole life is linked to contracts. There's some of my senior colleagues here. Some of the people following me on this webinar, I am getting used to some of the names here. I see people is coming back through all the different products that's presented by Lead here, from shares to deceased estates to a lot of other training. And you should actually you should actually now type to Mil in September and ask her to send you itinerary of everything that you can attend here if you don't have that yet. So thank you for all the guys that stick around. I can already see on this name list a couple of names here that's becoming very familiar to me, and I'm grateful for that. To the newcomers, welcome. To my colleagues, junior colleagues, esteemed senior colleagues, and the corporate world, very welcome. And then a very big welcome to people to candidates that knows me by now very well, and that is in history the Pioneers 2021 pupils for advocacy training. So I want to say to them, very welcome on this specific webinar. They're not joining with you now, but next week they're going to see all 4 recordings, and this is part and parcel also of the pupil training for advocates, the first ever, and they are writing their admission exams in September. So if you want to become an advocate and you've got a law degree, you must contact this institution, the LPC, look at those notices, and you must register before the 15th of this month. Pioneers, a brand new platform we created after months of working on the e-leader platform with all the material there, and there you'll see my face in a suit and a tie, or maybe sometimes a suit without a tie, a little bit more official. So welcome to those people too. All right, let's start. First of all, like I said on chapter 1, we say there in the introduction, everything is linked to contracts. What can you do in life without contracts? Everything is a contract, from paying your electricity bill to marrying one day, to being employed, to buying a vehicle, to having a bank account, to having a credit card. Where will I stop? Where will I stop? Everything inadvertently is linked to contracts. You cannot get away from it. And what we're going to be looking at predominantly through the next 4 days is on an advanced level, of course, commercial contracts. So you'll see there on page 4, we say there a commercial contract is a contract pertaining to or has bearing on commerce. These are contracts relevant to the world business transactions and relationships, and excludes contracts such as engagement contracts, anti-nuptial contracts. That's the exclusions, domestic employment agreements, and the like. We won't be looking at those. We're going to look at credit agreements, acknowledgement of debt. I believe there's a surety in there, and we're going to be looking at all of this. This is a very good foundation this is a very good source of income for all legal practitioners, and this is something that you must be able to do, and you must enjoy it. I absolutely love drafting contracts. When I get an instruction to draft contracts, I'm always happy. I'm going to lock myself in my chambers away for a couple of days, and I'm going to put it out at first, second, third, fourth draft, and I'm going to be take all the feedback that I can get from the clients through the attorney of record that has instructed me. I'm not a Fidelity Fund certificate advocate. I'm a normal advocate of old, and that's the way it's going to be done then. And I love this kind of thing. So this is something I am bringing to you that I really enjoy, and through the years I have gained a lot of experience in it. And I know there's some of my senior colleagues here that's just here because they want to recap, see what's going on, but they have the same experience or even more than me. The youngsters here, the newcomers to our legal practitioners industry, the people in the corporate world, they need to know this, because this is, like I say, a very good source of income. Or you are sitting there as a credit manager, or a financial director, or a credit director of a big department in a corporate, and you need to know what's going on. All right, guys, let's go to page 5 and let the fun begin. We're going to start with the fun immediately. Isn't that true, Mr. Peter Allenson? Welcome here, Mr. Allenson. Shall we start? What do you think? Yes, indeed. There we have basic drafting of contracts. That's on page 5. You can see my voice is lifting a little bit because now I'm excited. I'm going to start, and we're going to get into this. This whole chapter 2 is a whole course on the basic drafting of contracts with this institution, and we always advise that you do this before we get to advanced, because here we're actually giving you a template, and I personally believe that this template locally and internationally you can use basically as a structured template for all kinds of contracts, and you just need to take out what you don't want and put in what you want, and you can literally fit any kind of contract into this structure. All right, let's have a look at it. The following is the basic structure headings found in contracts. I'm going to go fast through it because it's actually basic drafting skills, but we need to start here because people that signed in here that haven't done that course. First of all, we have to have a heading of the contract and title. And if you were on the basic contract webinar, you would have heard a lot I'm saying about that, a lot I'm showing you court cases about it, etc., etc. We're not going to do it here. Sometimes we need subheadings in a contract, then you have to do that. That's number 1. You have to know in your contract. Don't lecture on that, James. I cannot lecture on this. That we do in another course. I want to go there. It's a normal habit. Then the party citations to the contract. After you've done your heading and your subheading, if that's relevant, then you cite your parties. And in terms of parties, there's a lot of stuff you have to know. A lot of stuff you have to know that's in the basic course. Agreement to the whole contract and all. I see people sometimes forget to put that in there. After parties in bold and capital letters, you'll start your contract by saying, wherefore the undermentioned or the aforementioned parties agree as follows, and lock it down, and then you'll start with your contract. And then if it's a long contract, look at 2.4, ladies and gentlemen. There at 2.4, you'll have an index if you have a contract that's, I'll look at 30 pages, 40 pages maybe. I'll start putting an index in there. That's up to you. You can decide. But if it's a short contract, I will not bother with the index. But if we're talking about tenders, we're talking about big contracts. Sometimes I've set up contracts that's over 100 pages long. And then obviously you have to then build the index in there. Preamble, there 2.5. Do you see that? Preamble, you can write there or type there. Another terminology for preamble is actually introduction. Isn't that true? And then you just introduce very quickly what this contract is about. You don't want to say too much there in terms of the fact that in the terms and conditions that's going to follow, you're going to repeat yourself. You don't want to be repetitive, but it's always a good idea on the preamble or introduction to just quickly say, in short, what is the history, where we're coming off, and what are we are desirous of doing. I use, when I put up partnership agreements, I always use the word, they desirous to go into a partnership agreement, and then I will be specific about what kind of partnership agreement is it. Is it ex-commodity? What is it? And that will draw back to my heading. That will draw back to my heading also. And then, of course, when you finish with that preamble, I always recommend the interpretation. I always recommend the interpretation, and I call it the open-ended interpretation. When I draft contracts in my chambers, I always get to this point and I open up my interpretation division and I keep it open until I have, after a week or 2 weeks, 3 days, it depends on how long it's going to take, I have finished. Because as I'm drafting through my contract, I come upon terminologies that I'm going to use that I realize the layperson or anybody else is going to find difficulty in understanding, and then I just build it and I build it and I build it on an interpretation as I'm going through the contract to the end. So interpretation is open-ended. You can really not lock it down until you've really locked down totally completing your contract, and that's very important for me. And nowadays, years ago on an interpretation, it was only about the meaning of words, but nowadays on an interpretation, we also built in there things like, you know, when I refer to XYZ, it's a company with registration number so and so. There's a lot of things happening nowadays you can build in there. Specific terms of a contract is very important. 2.7 there. I want to talk to you about the specific terms of a contract in terms of being important. This has to do with the essence of the type of contract you're drafting. Now, all contracts have certain requirements that have to meet. And if I'm not mistaken, as we're going through in the next 4 days, we have some definitions in here. For example, what is a credit agreement? If it doesn't meet these requirements, it's not going to be a credit. It's not going to constitute a credit agreement. And all those specific terms of a contract you will build in there to make certain that if a shareholders agreement or whatever it is, you meet the requirements to be a valid and legal shareholders agreement. All right, and then of course, after you've built that uniqueness, that's essence of your contract into your contract, you move on to paragraph 2.8. That is your legislative clauses. And one of the reasons nowadays that I have created in my contracts legislative clauses, if you think about the National Credit Act, you think about POPIA, which is the Information Protection Act, Consumer Protection Act, there's so many acts you can think of that you have to build in legislation information into, for example, a credit agreement, the consumer rights information about the NCR, etc., etc. And legislative clauses is very important. Some of the acts tells you what to do on the legislative clauses, but I want to say something here. I cannot move on. If I have to say something, I have to say it, although this is basic drafting. On the legislative clauses, I have become educational, especially if I put up shareholders agreements under the Companies Act. So there's a lot of things that when you say to directors or shareholders, okay, we're putting up the shareholders agreement. By the way, make a note there. Remember, when you register your memorandum of incorporation in opening a company, you can do it like that, or you can make your shareholders agreement part and parcel of the MOI. All right. So what I do then is I always have a chat with the directors or the shareholders or combined, and I'm always surprised that how much they don't know under the Companies Act. And when I pick that up, I become educational. And under the legislative clauses, I'll build in a lot more. Not only those things that a law requires me to build in there, but also on a legislative foundation of education, because there's a lot of difficult stuff, if I can call it like that, under the Companies Act. Then we go to your common terms. There's another word for it. You will most probably be better familiar with the concept of boilerplate clauses. And that is your operational machinery. Without common terms, the operational machinery of your contract is lacking. You need to build this in. Now, depending on what our kind of contract is, and depending on the selective, your selection criteria, you'll just decide what goes in there. But let me give you an example. When you look at common terms, then you look at 2.9.1. The whole agreement will always be in there. Hey, this is the whole agreement and nothing else, blah, blah, blah. This is it. Relaxation of terms. Very important to say that, oh, if you pay me rent and suddenly you want to pay me half now and then you'll pick it up at the end of the month, I can relax the terms, depending on if that's going to be that I can see that maybe that won't be always there. If you look at 2.9.2, that was free. Variation will always be there. That is an operational mechanism. If we want to bring an amendment to this contract, it has to be signed in writing, blah, blah, blah. Jurisdiction of Magistrates Court. We always want jurisdiction in there. Doesn't have to be Magistrates Court, but we want jurisdiction. We don't want to fall around with jurisdiction if we have a problem. Address for service, all my senior and my respected colleagues would understand. They were talking about domicile executandi. and address for services, then that, all that address. Remember, with address of service, it's not just the address of service. We have to say there. We have to talk about sending documents on an address of service to per email, per hand, per post, whatever the situation might be. Then we can talk about legal costs. Legal costs has got a few sub-departments there. What is going to be paid, legal costs for drafting of the contract, what's going to be paid for a contract. So that's also important that you look at that, and you can write it in there that maybe one party is going to pay for a contract. It's going to be so much. You can put it in there. You don't have to put it in there if you don't want to. Or both parties are going to pay 50%. But I have found in my contracts that I always ask, before I take an instruction on a contract, we agree on a set fee, and we agree who's going to pay it. And we agree that it's going to be in a contract. All right, I always do that. I always do that because I have come in situations when I was younger as a legal practitioner, and we didn't talk about those things. And later on, it's an argument about who's going to pay me and how much they're going to pay me. So we make it contractual, and if they sign it, they've signed it. Legal cost for litigation is a very important legal cost clause that has to be in as the parties are in dispute. How's that going to manage? And that draws through to your cost. Also, it's the party, attorney and client. And of course, there is rules and legislation also applying to what you can do there and not. And in further commentary, you can also go into further cost there if you want to. If you want to develop something unique within a specific field, you can elaborate on that. And then, of course, another one of the commenters is alternative dispute resolution, ADR. There you have negotiation, mediation, arbitration. By the way, at mediation, make a note there if you want to. If you want to read up more about mediation and how it is going to work if you are in civil litigation, even in criminal litigation, the best way to go read up on it is Rule 49, capital A. Rule 49, capital A. That comes to mind now of the Uniform Court Rules. And please, ladies and gentlemen, for everybody out there, I see there's a misconception and people are following around with this. The Superior Court is not the Supreme Court. The Supreme Court is your old High Court. The Superior Court is the courts higher than the Supreme Court, and each and every one has got its own act. All right. So Superior is not Supreme is not superior. Those are two different levels of court. Now, the reason I'm saying that is I see that if I say uniform rules, then obviously I'm talking about a Supreme Court. All right. So you have to decide whether you want alternative dispute resolution in there. You have to decide whether you want negotiation, mediation, arbitration in there, all of them, or just one or two of them. You've got to decide about that. The note I want to make there that I always make on the basic training is always tell your clients that arbitration is expensive. And that if you go the normal route, it's easier. Now, maybe you have a question for me, right? I think you might have a question for me, Mr. Besainenhout, Niels Besainenhout. You might have a question. You say, but you know, can I have a normal breach clause to versus an arbitration clause in the same contract? It's a very logical question. Yes, you can. But the mistake I've seen is people copy and paste. Yes, that's right. People copy and paste, and we all do it. We all do it. And what happens is then mistakes are made because after they've copy and pasted, they don't read. If you're going to build an arbitration clause in there to deal with certain issues, and you're going to build a normative breach clause in there on page 6, I'm on page 6 now, I'm going to scroll down here. I mustn't forget to do that. There we are, 2.9.8. Then what we're going to do there is that you're gonna build them in relation to each other. For arbitration, we're going to do this, but we retain this right. Or arbitration, we're going to do this, but on a breach, we're going to do this. You got to accommodate them that they don't stand in conflict to each other. And that's, if you can do that, you can draft it in that manner. You can have both of them there. You're good to go. 2.9.9 there on page 6, we have governing law. Governing law is very important. I've done cases in South Africa that we had to translate some contracts from Mandarin to English so everybody can understand it. So you're going to decide what law is going to apply. If they say the Chinese law is going to apply, then South African court can apply the Chinese law. There's court cases on this, and under drafting basic, I teach you these things. We talk about it. So you must decide governing law is going to be South Africa, Namibia. What law is going to be applicable here? That does mean you have to travel to Namibia. Well, one of the Chinese cases I did, they were going to do Chinese case, and then the South African law, the court had to apply the Chinese law. That's very difficult. Very, very difficult to do, but I do it. Joint and several liability clauses are also important there. And please, ladies and gentlemen, 2.9.10 and 2.9.11, I've seen confusion there. People confuse several liability with severability. Yep, the English, I suppose. Né? Oh, my English wife hears me now, I'm in trouble. Right, so several liability, joint and several liability has to do with liability together or individually, depending on what's going down. But severability is cutting away right there. Make a note there, it's cutting away. For example, the severability clause is a very good clause, and I think all contracts must have it in there. And basically, in good and understandable English, it comes down to the fact that if there is a clause that's illegal or unlawful or whatever the situation might be, the court can cut it away without ordering the whole agreement to be unlawful. And of course, there's requirements. Remember that severability also doesn't just stand at, yippee, well, we can cut stuff away. You cannot cut anything out of a contract if it's going to negatively impact on the whole contract. Then it's better the whole contract has to suffer the consequences. Uh-oh, I swallowed the English dictionary just now there. All right, so that's important. Confidentiality. Confidentiality clause is becoming more and more important in our contracts nowadays, especially after the promulgation of POPIA, being the Personal Information Protection Act. And in most of my contracts, I discuss confidentiality on the various levels, because you can have limited confidentiality in terms of specific issues. So you need to discuss this with your clients. And but I insist in most of our agreements that we deal with it. And you will see now when we talk about the next chapter, you'll see there why this is so important. Why under POPIA, why confidentiality, for example, when you apply to a bank for a loan, why this is so important. We're going to tell you everything. I'm going to show you what's important. Execution of the contract, you can deal with that. That's easy enough. And counterparts is also easy enough for those people who doesn't understand counterparts. Execution is easy enough. Counterparts, this is all basic. We do this on a basic, in-depth. Not going to do it here. Counterparts is actually, I should type there, signing in counterparts. All right. Then, look at this, ladies and gentlemen, 2.10, annexures. Annexures is an official a clause in my agreements nowadays. And the reason I have approached contracts differently is actually it came from the National Credit Act, where the law actually says that if you annex documents like sureties and stuff like that to agreements, that you cannot just say anymore, annex so-and-so suretyship agreement. You have to, in a short paragraph, summarize what that attachment is about. And that is why annexures is very important for me. And I always have annexures. Let me show you why I have always annexures. If you give me an instruction to draft a contract, you have to have patience with a guy like me, because you don't come to me and say, listen, I want a contract tomorrow morning, and please, you have to keep it short. Go to another advocate. I'm not going to help you, because that's not the way I work, because there is so much risk there. One of the biggest things we do when we draft contracts is the whole time we contemplate mitigation of risk, but not overkill. Why am I saying not overkill? A client comes to you, set up a contract. What is his desire? It's for that contract to be signed. So he wants you to mitigate the risk, but he doesn't want you to overkill. What does overkill mean? Overkill means that the other side is not going to sign it. They're going to give it to the lawyer and say, this guy is crazy. We're not signing this. So that is important factors. Now, why did I bring you back to page 5 again? There on page 5, if we scroll back there to the beginning, you'll see the parties to the agreement 2.2. And I always attach copies of ID books or wind deed printouts on juristic persons. Always, always, always. I make certain that identification is priority. Because I've had so many cases in the past where I get an instruction to draft. They even give me a resolution. And when I pull a wind deed, I say, but this director, with this resolution, everything that seemed fine on face value, but he resigned. He's not a director there anymore. Stuff like that. So I always have annexures to prove the status quo and on terms of legality. Right, then 2.11, guys, come on. Who sets up a contract and doesn't date it, put a date in there and indicate a location? Dating and the location pertaining to the signing of the contract. You'll be surprised how many times in a boardroom I've been called in, an attorney of record wants me there from the beginning. We're going to do a breach of a contract. We're going to do litigation. And I'm sitting there listening to the story being told, and they shift the contract over to me. And I quickly always go to specific things, because I've been drafting for years. I always page and I look for specific things, and I listen to what I say, and I know precisely what I'm looking for. And I say, but hey, this thing is not dated. And then we have to fall back to what? what we're going to be talking about in the next chapter: electronic data and the ECTA Act. And then we have to fall back to emails to proof dates and stuff, run around and so on. So come on, guys, you got to date your contract. And in terms of jurisdiction, right? In terms of jurisdiction, if you say Magistrates Court, here you will say Pretoria, for example. You've got to put that stuff in there. Now, it's very important, and my senior colleagues online will understand what I'm saying, but the newcomers to my field, as legal practitioners, and it's important for the corporate world to know this. And as for the first time in the history of the country, the first trained advocates is going to be listening to this. So let's say this, that when you start the action procedure, and under the action procedure versus application procedure, deal with summons, simple summons, combined summons, and then of course I'm coming down to particulars of claim. When you do particulars of claim, and it's a case about a breach of contract, contracts are involved, you have to state according to the rules between 17 and 19 of the Uniform Court rules, for example, that where was this contract signed. So we have the MAC Court, we have the High Court's jurisdiction, but we need to know where. And you have to make that development in the POC. The POC being the particular of claim. So that's what I wanted to bring on your attention there. A little bit more than just what we're doing here, but that's also better than not. So then, yeah, of course, you've got to sign your contract, signatures. And we are going to talk about this under the electronic signatures, etc., etc. I think that's the next chapter we're going to. So you've got to sign your contract. Now, signing your contract, I've got to say something about it. I cannot just page on and do this too fast, although it's on the basic. Signatures are problematic. I mean, let me show you. We can sign it physically with a pen, or there's two ways on the electronic signatures. We can do it. It will fall back to your heading or your identified in your email, or it will be a specialized electronic signature. But that's not a point I want to make. You know that when you sign a contract, you'll sign it fully on the last page, and you never, guys, make a note, it's in my brain suddenly, you never leave gaps. I've had too many cases on that, where gaps were left, or open lines were not a line pulled through it, and people went later on and write stuff in there. I've had cases, you won't believe how many. And that's fraud, by the way. So under signatures, what is alarming to me is if you look at the National Credit Act, then of course, you have to highlight clauses in a contract, bring it to the attention of the consumer that is, let's say, negative clauses, not illegal clauses, not unlawful clauses. I'm calling it negative clauses. It's overbearing clauses. It places a more restrictions or overbearing restrictions or whatever the situation is on the consumer, but it's not illegal, it's not unlawful, so you can have it in there. But then the law requires you that you must bring it to the attention. And one of the things I do there is I make it light gray at the back. I put a bold line around it. I put in initials, date, initial, and I type in the paragraph number there. You would say to me, but it's below the paragraph in the block. I'm sorry, I'm not listening. I'm not an academica advocate. I'm a practicing advocate. I've seen it go wrong. People argue about that was pertaining to the next clause, and then we're in a fight. And why will the opposition not take a chance to argue something like that? And that's why I write also paragraph 9.2. We know where we are, and they initial at that overbearing, let me call it overbearing clause in terms of our legislation currently. And I have expanded my contracts. Independent contractors contracts, employment contracts. I've expanded that in my chambers. And what I'm doing now, if I draft a clause and I think in my heart that, wow, you know, if this clause was in a contract, I want the people to show it to me, to make a special effort to say that you see that. Are you satisfied with that? And then that's how we do it there. Oh, yes, and then interesting enough, look there at paragraph 2.30. Do you see that page numbering of the agreement? Now, that's very interesting. I don't know why people don't number their agreements, but let me tell you a story. As a junior advocate, this happened to me. I became an advocate for a year. An instructing attorney gives me a case. It's a case in which one company in Cape Town bought steel from a company in Johannesburg, a lot of steel. Was over 250,000 rand. Those were the days when steel was still cheap. COVID has turned that on its head, haven't it? As well as building all the sports stadiums as another reason there. And the Cape Town company was liquidated, blah, blah, blah. That's the situation there. And what happened there, of course, was that there was a contract. and there was annexures, and the annexure was a surety, and at the end of the day, there was a lot of problems with that, and the contract was of a difficult nature. We cannot do anything about it. And at the end of the day, I couldn't take the case further. The attorney of record kept on hassling me. And one afternoon, I was sitting in my chambers in Pretoria, and I was looking at this case file and wondering if there is anything we can do, because we're dead in our tracks. And I was sitting paging through the contract. And I'm paging through the contract, and I've never looked at this before in my career. And I'm paid, okay, I was junior, so I was paging through it, and I see the contract ended at number 22, and the page numbers had the same smudge right through. I don't know if they've chased it through a photocopy machine or whatever. And the surety was part and parcel of the contract. And opposition was saying, this surety is not part and parcel of this contract. And I saw the numbers going on, 24, 25, 26, something like that, including the surety agreement with the same smudge. And the signatures, everything was in order, and that's how we got beyond that. So page numbering of an agreement is very important for me. I wanted to share that. I had one case in my whole career on page numbering, but I will never ever forget it. And it ended up that after we showed this to the opposition, who said, but you are malicious, this is what you are doing here is totally unacceptable. It was acceptable in the beginning, but now we're going to make something out of this. We reached very quickly after that a very amicable settlement in the favor of our client. Because now they were embarrassed because they were pulling a fast one, and they had us with the fast one, although they know they were lying. And that's another thing. Advocates and attorneys do not lie for their clients. Very well, that's it. That is then a summary of the whole basic drafting course if you have not attended that. For the pupils that's going to be online next week listening to this webinar and what I'm doing here, by now they must be fed up with my face, because within that platform, every time you open something, my face is up there and I've got something to say. So I also recommend that you contact Merlin September, the pupils that I'm going to be dealing with until September, and it's in your benefit to book the basic drafting. Because when I look at candidate attorneys and I look at pupils, I remember how difficult I had to start my practice, and I like to show you where you can make money immediately and empower you with knowledge to do it. And contracts is definitely one of them. All right, ladies and gentlemen, thank you very much. That was then chapter 1 is finished, chapter 2 is finished. We're now on page 7. Isn't this amazing? Do you enjoy your work? Do you enjoy what you are doing? I enjoy my work tremendously. I tell you, every time I get something to do like this, I'm like a youngster that found a new toy to play with. If it comes to litigation and unraveling investigations, drafting of contracts, particulars of claims, founding affidavits, opposing, drafting. For me, this is closing the door, telling everybody in the front of my chambers, you got to be quiet for this week. And I disappear into something I really, really enjoy. You got to be positive about what you're doing. I never made a mistake becoming a legal practitioner. I never made a mistake becoming an advocate. I really enjoy it. So many of our colleagues are always grumpy and so on. That's totally unacceptable. We must not do that. You must enjoy every second of your job, and then you will be super successful in it also. Page 7 of 68 there, contracting electronically. Now, this can be difficult. Isn't that true, Francis Berger? This can be difficult. This can be difficult. Let's see if we have made on the extractions we did it a little more easier to understand. All right, so we're going to go slowly through it. I want to read everything in here to you, and I will elaborate as I'm going on. Of course, we're working with ECTA. ECTA is then the Electronic Communications Transfer Act of 2002. And please, ladies and gentlemen, my junior colleagues, my respected senior colleagues, make a note there. There is 2 communications and communications acts, actually I must say electronic acts in South Africa. This is one of them. There's 2. Go and Google on the internet and you'll find the other one. Electronic contracts are only valid if they meet the requirements, the essentialia of contracts. Normal 101, when you was at university, you got your law degree, what did they teach you? When will a contract be valid? We're looking at consenters, capacity, legality, possibility, must be possible. And if it is the case, a 5th one, we call that formalities. Like, for instance, let's pull one out of the hat, National Credit Act. If you work with agreement there, it must be in writing. That's a formality. So Your electronic contracts is precisely the same. The first thing I want to teach you today is when you draft contracts that's going to be electronically applied, the requirements for a valid contract is precisely the same. So never be threatened by that. I have a lot of people always ask me, but what should I do now? Where should I look to make this valid? Is there a difference? It's not a difference. We are sitting with the same type of court cases, the same things we're going to be fighting over, except that electronically it becomes much more complicated on the foundation of those components, but not the usual requirements for a valid contract. That's got to be there. If that's not there, you got a problem. The essentialia for a valid contract under South African law are that there must be a valid offer and acceptance, and consequently a meeting of minds or consensus between the contract parties. Where only one party has contractual capacity, a limping contract, which can only be enforced against the party with capacity, will be formed. There's a lot of reasons that you can have a problem with capacity. Minors, incompetent, mentors, compos, stuff like that. Non-mentors, compos, sorry. The contract must be legal or lawful and be capable of performance. That is the fourth requirement. Usually, is it possible? Can we do it? Otherwise, it will not be enforceable. Generally, there are no prescribed formalities for the conclusion of a contract. Yeah, however, formalities are prescribed for certain contracts, such as the sale of a land and credit agreements. And those formalities, usually when legislation comes to say, well, if you put up a contract like this, we want that in there, we want that in there, we want that in there. What do we mean for those guys out there that's newcomers to whatever we are doing here in contracts? Essentialia, meaning terms required for existence of a particular type of contract. For example, a sale or lease agreement. Now, if you go back, you don't have to page back. If you go back, you remember on page 5, paragraph 2.7, we said specific terms of a contract, and that links up with that. That is the specific nature of this contract. And if you don't comply with the requirements for that thing to be a sale contract, a lease contract, whatever surety, whatever has to be in there, you don't have a valid contract. All right. The validity of a contract may be affected by misrepresentation, mistake, or duress. Those are the three common things that can happen. Make a mistake, or you're under duress, or there is a fraudulent misrepresentation, which usually has to do with the fact that you would not have signed it if you knew the truth, and things like that. That can also impact on the validity of a contract. So here's the first lesson. If you're a drafter of a contract, you have to be transparent in terms of the truth. You cannot not be transparent. If you are drafting a contract and you're working only with your client, that's easy enough. That cannot really become a problem, except if you catch him in being acting in a manner of being misrepresentative towards the other party. And in any event, you cannot lie for your client. The moment you've uncovered something like this, then it has to be remedied, or you're going to do the walking. So I've had that before. I've walked away from things where people say, no, they don't know about this. Can you put it in words like this? And I said, oh, stop. I'm not going to do this. You should rather have remained quiet. But now that I know, I'm under the code of conduct, and there's two codes of conduct for me. I've got a legal practitioner conduct nowadays, and still the advocacy code of conduct, and I'm not going to do it. And not because only I'm on a code of conduct. I'm not going to be a party to some sort of scam. I'm just not going to do it. All right. And then the time and place of conclusion of contracts are important because they relate to jurisdiction and applicable law. We already said it. And electronic, that can be challenging. That actually is the biggest problem with electronic contracting is where is the jurisdiction? And what does ECTA say about all of this? All right. Okay, good, excellent. We will break. Don't worry. We're breaking on the hour. 1 o'clock. We'll break for about 7 to 8 minutes for that cup of tea. Glass of water, nothing stronger. All right, guys, let's go on. Time is of the essence. Reception theory. We have to look at the reception theory because that's applicable to ECTA, to electronic contracting. Now, what does that mean? When the offerer receives the exception, applies to contracts concluded via data messages. Contract is concluded when a data message containing the acceptance enters the information system used by the addressee and is capable of being retrieved and processed. Make a note. It has not been retrieved. It has not been processed. It's capable. So it's left, may I say, your server. It's now in that system, information system. And if the other party clicks, then it can be retrieved and it can be processed. Place of conclusion is where the person to whom is communicated usually resides or does business. There is jurisdiction. Make a note of that, because this is the thing you keep on. Attorneys would phone you and say, listen, you know, they wouldn't go on the internet, they'll phone you and they say, where is jurisdiction? Here it is. Section 22 of ECTA provides that the reception theory applies to electronic transactions. The law says it. ECTA also provides for when data messages are to be considered as sent and received as follows. And there we look at section 23A and B. A said the following to us. A data message must be regarded as having been sent by the originator when it enters an information system outside the control of the originator, or if the originator and addressee are in the same information system. It's like they all work in a bank and they've got this mutual server they're working through, this information system. I mustn't say server, I'm not a specialist on these things. When it is capable of being retrieved by the addressee. And then B says a data message must be regarded as having been received, underline this because this is important, by the addressee when a complete data message enters an information system designated or used for that purpose by the addressee and is capable of being retrieved and processed by the addressee. Not he has retrieved it. I want to make that point very clear. He's capable of retrieving. You send it out. So that means I receive a contract from you electronically. On my side, I do something that electronically indicates I've electronically signed it. I send it back. It's a done deal. Whether you've opened it or not, it's a done deal. This is what this is saying. Be careful with this. And then, of course, let's prove it. Here it is. These two concepts were in issue in Jafta versus Ezemvelo KZN One Life, that court case there in 2008. Interesting enough. Ezemvelo has a site on the other side of Bronkhorstspruit also where you can go and run and walk between the animals. Oh, all right. So that is where this then happened, and they said this is how it's going to work. ECTA also provides for where a data message is taken to be sent from and received. So let's have a look at section 23C, which provides that a data message must be regarded as having been sent from the originator's usual place of residence and business. That's jurisdiction on his side. In the first one, jurisdiction on the other side. Now we're dealing with the person that sent it. That is jurisdiction on his side. Make a note there. And as having been received by the addressee at the address usual place of residence or business, and then that's jurisdiction on the other side. And this is very important when we want jurisdiction for any reason. Civil litigation comes to mind because we are legal practitioners. Furthermore, section 25 provides for the attribution of data messages. A data message is considered to be sent by the originator if he sent it himself. Now you're gonna listen. This is interesting because we can do it, or a computer can generate it. So this is important. All these letters you're getting from the bank that says you're a bad payer, and you want to phone that guy's name that's on there. But that guy's name who's on there doesn't even know he sent you that letter. What an automated situation. So no need to go and shoot somebody, except maybe the program, the computer doing it. And no, not really. Not really. Don't do it. I know how you feel. COVID has had it all in a grip, and a lot of us are recovering. And we are recovering because we're positive, we like what we do, and we are overcomers. So if you're in a difficult spot, I don't know why I'm saying this, you will make it, and there's no other way to it. I know a lot of our legal practitioners, especially advocates, had a rough time through COVID. All right, let's see. Sorry about that. Section 25. A data message is considered to have been sent by the originator if he sent it himself, or it was sent by his authorized agent, or an automated system programmed by the originator himself or his authorized agent, unless it can be showed that an automated system did not function properly. And that is important that you understand, that you're also bound by the automated system or by the authorized agent. And then, of course, if it's personal, then it's personal in its human nature, if I might put it like that. Then, of course, what does section 26.1 says? It provides that the agreement is valid upon the receipt of the acceptance, and it's not necessary for an addressee to acknowledge receipt. Please have a look at that. 26.1 provides that the agreement is valid upon the receipt of the acceptance, and it's not necessary for an addressee to acknowledge receipt. So that is very important there. All right. Okay, guys, take a deep breath. I'm going to take a sip of this water, because they just told me there we always give you a bottle of water. You never drink it. So I better drink it or they're going to be upset with me. All right, online agreements, paragraph 312. Let's see what we can tell you about that. This is actually what you deal with on your laptop on the screen the whole time. There are numerous categories of online agreements, which include contracts for sale of tangible goods, the supply of digitized products, and the supply of service and facilities. The principles of contract law apply to online agreements, and to be valid, they must comply with the necessity alia of a contract as outlined above. We already said that. Online contracts may be concluded in various ways. If you go down, you can read it further in your own time. If you go down, you will see we've got 3 there for you. Shrink wrap contracts are those where the terms and conditions are printed on paper and placed with the shrink wrap packaging of the goods sold. For example, a CD containing a software package. The purchaser signals his assent to the terms and conditions by opening the package. So there you have that. You know, if you're my age, you drink a lot of vital vitamins. And the other day I see that you really had to tear off the plastic to get to the paper and the terms and conditions in there. The sixth one is browse wrap contracts. Bind the user of a website to a contract created by the user mere browsing of the website. I want you to mark that one as dangerous. The moment you go into the website, you are bound by the terms and conditions. This is something you have to look at. A lot of people don't know. They go in there, they muck around, they push buttons, and they don't know from the moment they have access there, they're bound by that. And then the third one is the one we all know very well, the most obvious one, and the one I need to talk to you about when you contract. With regard to click wrap contracts, the purchaser or user of a website is required to indicate their assent to the contract by clicking on an icon. And this is the one we use most of the time. And I just want to talk about that one quickly. If you are instructed to draft a contract like that, you'll be working with IT, because you'll do the legal contract drafting, and then you'll have to sit with ID, and you'll have to say, if there's a specific clause in that online contract that's problematic, then they have to make you click on that too. Otherwise, that contract will be illegal. Oh, all right. I must scroll down apparently. So one of you just made them aware of that. They just run in and say, I'm not scrolling down. Yeah, that's a problem. I apologize. Thank you for whoever said that. That's quite. I appreciate that. All right, that's then online agreements. There, when you go there to that click wrap contracts, make certain that the IT people follow the law. So if there's 10 clauses in that contract that has to be individually clicked, then he cannot just go electronically to the end of the contract and click there. Then it's going to tell him, no, there's 5-7 clauses that you didn't individually click, and that's where your problem lies. All right, guys. So that is then important there. Let's go on there. I'm scrolling. Do you see I'm scrolling? I always forget. My apologies for that. Whilst each of these types of concluding a contract there on the top of page 9 are valid and can create binding contracts, some contracts may be voidable if the buyer's attention is not drawn to the... Okay, I've said it. That's precisely what I've explained to now. And then, of course, the last sentence there in that paragraph is important for me to bring under your attention, and that has to do with the consumer must also be given an opportunity to accept or decline the proffer terms and conditions. And in 1999, that was Durban's Water Wonderland versus Botha. And again, as the legal practitioner, you have to sit with the IT. I have had this before. I don't want to mention the client's name, but it's a big client, almost like DHL and them, not those clients. And we went online and we had to do this. And I quickly picked up, after I've drafted the contract and I give it to the IT to load, I have to sit with him to tell, this is what I want. And then we have a little bit of a debate about it. And of course, he makes it happen. All right, when it comes to enforcement of online contracts, a traditional contract law approach is taken. And the party seeing recourse has to consider the same factors as considered by a person suing on a contract concluded in the bricks and mortar world. It's the very same. The requirements are the same, and that's how it operates. Right, guys? Then we're going to automated transactions. Now, let's look at this computer robot situation, as I call it. This is now when a program is picking up your on arrear or whatever the situation is, and they're throwing out there, or they are controlling the whole contracting process. It's been totally automated. And if you sign it, you're actually signing it with this automated system. And that's how you bind yourself. Let's have a look at it. Automated transactions are defined by Section 1 of ECTA as electronic transactions conducted or performed in whole or in part by means of data messages, in which the conduct or data messages or one or both parties are not reviewed by a natural person, in the flesh, I may say, in the ordinary course outlined above, apply to these contracts. However, due to the unique nature, protection for the parties needs to be expressly provided for where an error has occurred, obviously. Because how many times have you had it in the past that is a mistake in your banking account or whatever the situation might be, and if you go to the bank and you get upset and say, it's not us, it's the system. And please be calm, we'll fix it for you, but it's a system. What I actually saying to you, it was not a natural person that was involved there. The automated system made a mistake. Now, how do we deal with this to be on the side of the consumer? And what must you know when you draft something like this so you draft legally correct? In Section 20 of ECTA, where it provides that an agreement will not be formed where a natural person interacts directly with the electronic agent or another person Y and has made a material error during the creation of a data message, and the electronic agent did not provide that person with an opportunity to prevent or correct the error, then how is it going to be valid? How are we going to have a legal agreement? The person notifies the other person of the error as soon as practical after the person has learned of it. The person takes reasonable steps, including steps that conform to the other person's instructions, to return any performance received, or if instructed to do so, to destroy that performance, and the person has not used or received any material benefit or value from any performance received from the other person. Now we're going to read it again too. We're going to discuss it a little bit later on again, but what do we mean with an electronic agent? Meaning a computer program or an app or an electronic or other automated means used independently to initiate an action or response to data messages or performance in whole or in part in an automated transaction. And if you can, they underline automated transaction. So you're not in that moment working with a person. You're working with a program person, you're working with an app, an application, and that's why they set up Section 20 to protect you if one of these things go wrong, or there's a lack on their side, not to give you opportunity to rectify whatever has gone wrong. And there we are. All right, guys, that is then very important. It's very important that you understand the legalities of this, especially if you're drafting a contract or based on a contract, you're going to go into civil litigation. And then, of course, you've got to know this. If you don't know this, how are you going to prepare optimally your client's case, whether it's a defense or whatever it is? All right, going then on, we are paging now. We are going now to page 10 of 86. And I have scrolled there. Let's quickly see what they are saying to us there. Where such software or automated means are used under Section 20, under ECTA, we must consider the following. Now, let's slowly read what it says, because we took it out of the Act for you. So it's the same thing. We don't think you're stupid or something. That's not the intention. It's the same with deceased estates. We are repetitive in when we teach and make certain that you fully understand what this is all about. So we're not thinking the least of you. We're making certain that you know what the law is saying specifically in this. Otherwise, you're going to draft wrongly. You're not going to understand what your goals are. You're not going to understand what you can do or not do when you draft on this foundation. All right, let's do it. In an automated transaction, an agreement may be formed where an electronic agent performs an action required by law for agreement formation. An agreement may be formed where all the parties to a transaction or either one of them use an electronic agent. There you have it. A party using an electronic agent to form an agreement is subject to paragraph D, presumed to be bound by the terms of that agreement, irrespective of whether that person reviewed the actions of the electronic agent or the terms of the agreement. A party interacting with an electronic agent to form an agreement is not bound, and this one is the important one, by the terms of the agreement unless those terms were capable of being reviewed. Mark that much more bolder if you can, by a natural person representing that party prior to agreement formation. And if you are the drafter of this contract, ladies and gentlemen, you must bring this under the attention of the IT that they can build in the structures to make this possible. Otherwise, you're going to get hiding in court and your contract is not going to be corrected. And that is why legal practitioners are moving more into the world of IT in terms of electronic contracting, because we know the law and they know how to program and build apps and things like that. And then again, we repeat ourselves. no agreement is formed. Underline that no agreement is formed where a natural person interacts directly with the electronic agent of another person has made a material error during the creation of a data message, and then it's precisely what we said before. All right, so you can read that on your own. We already said that those four pointers there is then very important to understand if you are drafting. All right, let's go on. Concluding a contract online or by email by means of a data message using an electronic signature can cause uncertainty in terms of whether the contract is legally enforceable. However, with the introduction of ECTA in South Africa has recognized the legality of data messages and electronic signatures and provided some legal certainty in relation to electronic contracts. So I want to say something now. Before we read further, I want to say something so that when we read it in this complicated language for the people out there listening to us that's not legal practitioners or newcomers to our field, is basically, in my view, there's two ways. You have your electronic signature, you can do with your electronic pen, whatever that situation is. There's an organization you can actually register your signature with, or your name can be printed as a heading or under an email or whatever the situation is, and that can be deemed to be your electronic signature. Now, I want you to keep that in mind as we're going further with this. All right, let's do it. We've got about two minutes left before I'm going to break. Let's do a paragraph or two. Concluding a contract online or by email by means of data message using electronic signature can cause uncertainty. We say that. The next paragraph, a data message is defined in ECTA as data generated, sent, received, or stored by electronic means. There are two types of electronic signatures, this being data attached to, incorporated in, or logically associated with other data, and which is intended by the user to serve as a signature, headings, or your name printed under the email. The second type is an advanced electronic signature, which, although being similar to a normal electronic signature, is far more secure, as an advanced electronic signature can only be created using a digital certificate issued by an authentication service provider whose products and services has been accredited by the SAAA, which is the South African Accreditation Authority. And we're going to stop right there for this hour. I'm going to take a break for my voice. Let's go and have a quick cup of tea or something, and I'll be back 7 or 8 minutes past 1. All right, guys, that's about that. I'm out of here as soon as I can find a tab to just to put this up for a couple of minutes. Let's see if I can do this. What do we are? There it is. Okay, guys, I'll see you in 8 minutes. Okay, guys, we're going to start in 50 minutes. Sorry, 50 seconds. We're going to start in a couple of seconds. So let's get settled in, and then we can go on. All right, there we are. We always have a break. Every time I spend time with you, there'll be a break there, and so on. All right, guys, I'm back. I hope you have gotten yourself a cup of tea or whatever the situation is. You feel refreshed. Let's go on. So what we said is that you have to go through the South African Accreditation Authority for that specialized signature. And then I go on to say that there on page 11, this recognition has paved the way for organizations to move towards operating a paperless environment and take advantage of concluding contracts electronically by means of sending a data message to each other in certain instances, or by attaching an electronic signature to a contract, thus reducing a large amount of inefficiencies within organizations. And that is the direction. If you think about the fact that we're in COVID now, and this is on the forefront, going electronic with everything, and people are actually working from home, then yes, it's been pushed harder and faster than ever before. In addition to how ECTA defines electronic signatures, going to state in section 13 sub 3, where an electronic signature is required by the parties to an electronic transaction, and the parties have not agreed on a type of electronic signature. Now listen to this, it's going to fall back, it's going to have a fallback. To be used, that requirement is met in relation to a data message if a method is used to identify the person and to indicate a person's approval of the information communicated. And having regard to all the relevant circumstances at the time of method was used, the method was reliable as appropriate for the purpose for which the information was communicated. And one of the best fallbacks you can have, for example, is when you release a report and like my name, I release a legal opinion as Advocate James Clark on top of it, or my email address, or I write the email and below it I print my name. Those are all fallbacks, and it can be either of them depending on which you used. The Supreme Court of Appeal helped provided clarity in section 13 sub 3 in the case of Spring Forest Trading CC versus Wilberry. In this case, the lessee has sent an email to its landlord cancelling the lease agreement, and the landlord responded by email confirming the cancellation. Now, what happened basically in that case, let me explain it to you out of hand, is that everything on the email was agreed on. Later on, they jumped up and the landlord said, well, the contract says that the variation or amendment has to be done in writing and it has to be signed. And then what happened in this specific court case, you can go later and read it. I'm not going to read the whole thing to you. I want to go on. We need to reach a certain point today. What happened in this court case is, the court went and they said, but sorry, this qualifies that it was signed by the landlord because in the email his name was there. Let's have a look at it. If you go there, I've paged down there. If you go there to the second last paragraph, that's just above paragraph 314, you'll see the outcome of the case means that when corresponding by email, we need to be very cautious and consider very careful what is put into an email, in particular when a correspondent relates to the cancellation or variation of a contract. Section 2A of the Companies Act provides that documents regulated under the Companies Act may be signed by any form of electronic signature as provided for in the South African Electronic Communications, which is ECTA. So, for example, it's valid to sign board resolutions electronically. And so you can read through that court case. You'll see there I've scrolled up. After weighing up both parties' very detailed arguments, the court found that the names of the parties at the bottom of both the emails were intended to serve as signatures, constituted data which was logically associated with the data and the body of the emails, and identify the parties. And that will stand. That will stand until somebody proves otherwise. So that's very important. That's why I always say to people, be careful what you say in emails. And sometimes when I work on a contract that has not been signed, a couple of cases I've had like that in the past, I go back in that time period and we pull the contracts where they spoke to each other, and amongst others they would say, okay, this is now finalized, we have the contract, it's all good to go, and I'll use that emails with the names under it to substantiate the legality of an existing valid contract. So that is how I deal with that. So there you have that. Very interesting stuff there. I always like these court cases. They're so very interesting. All right, paragraph 314, page 12. Let's go look at EDIs. You're always used to hear the terminology EDIs. Another word for it is interchange contracts, but EDI actually means electronic data interchange agreements. And the biggest group of people that uses this that we can think of, and we are using that example in this guide also, is the airlines. Let's have a look at it. Let's go through it. It's very interesting. Now, before I start reading here, let me plant the seed in your mind. When you draft contracts in this line, you are drafting on future events. People agree now on what is going to happen in the future. And there's so many role players that the EDI system brings together, from caterers to booking a specific seat, etc., etc., etc. And that is what we're looking at. So keep this in mind while I'm talking. We are deciding on something in the future. These are agreements where traders contract upfront with one another as to which term or rules will apply to future transactions. Such transactions save expenses for traders by replacing data exchanges by human interaction with electronic alternatives. In practice, for example, the international airline industry, with the use of EDI, makes it possible for individuals to obtain online boarding passes with precise seat allocation without the need to visit a check-in counter before obtaining a boarding pass. All this can be done from home online and includes upgrades, dietary requirements, and much more. The EDI between the booking operator, the airport operator, the flight operators, and the various flight caterers makes it possible for everything to be agreed and supplied as agreed. It is also important to understand that for the communication and understanding of data to accomplish this, uniform rules and standards must be set in place. And that also have a lot to do with legislation. And there also, as a legal practitioner drafting this or amending this, you must go and look at the law. And if there's physical electronic information that should work, like clauses within a bigger contract that has to be independently clicked, then the legal team has to sit with the IT team and make certain whatever the IT team does, it complies with the law in terms of specifically then here on the contracts. It is also important not to forget that before any of the above relating to data, messages, or electronic signatures is to be considered, one must first ensure that a contract deemed to have been concluded meets the common law requirements of a contract for it to be legal and enforceable, such as there being a valid offer and acceptance. That's normal. There being consensus between the parties, both parties having the contractual capacity, not being a minor or to be able to enter in a contract, whatever that situation is. Meeting of the minds. Let's just quickly say something about meeting of the minds. I want you to be very careful when you contract. If I'm selling a green apple, I'm not selling a red apple, but I'm still selling an apple. That is the meeting of the minds. The meeting of the minds is the detail. And you must have an eye for detail if you contract. You must make certain that you encapsulate the terminologies you are drafting for your clients in a contract absolutely in detail and absolutely correctly. One must also ensure that a contract being entered into line is not one that falls within the exceptions, not being able to be signed electronically, such as an agreement for sale of a movable property. That's legislation. A long-term lease agreement of a movable property which is in excess of 10-year period, that is legislation. A will or a negotiable instrument such as a check. Now you would ask me most probably, why are you still talking about checks? From the beginning of the year, checks are redundant. We cannot use them anymore. Stop the bus. We still need to talk about checks as one of the three, I think it's 3 or more forms of negotiable instruments, because you have promissory notes and stuff like that there. Why are we still talking about checks? Checks might be in the position that we don't use them anymore, but we can still litigate on them. There can still be damages on them. And in any event, from the beginning of the year until, at the very least, the next 3 years, in terms of prescriptions specifically, we're going to stick with checks because we can still do litigation on them. So that's very important. For example, if we have a contract and checks are involved and there was misrepresentation, then those things become paramount in terms of checks. Remember that. And it's not to say it's only 3 years, because strictly speaking, some of my colleagues might have picked it up. What is the prescription area for negotiable instruments? Is it 3 or 6 years? That's right, indeed. Mr. De Villiers, Andries Gerardus De Villiers. It is indeed 6 years. All right, guys, chapter 4. That is there now. Now, what we have done, We have showed you a basic template. We have spoken a little bit, extracting what we think is important in terms of electronic contracting, what we think you must be looking at. There's much more, obviously, but we only have so much time here. And we always bring these courses to you fast, on a fast track. Fast, 2 hours. 4 sessions on this one. And obviously, there's a lot of things we cannot canvas. Please take that into consideration. You have to go back and also make certain from your side as a practitioner or in the corporate world that you do the necessary research and make certain everything is correct that you draft. Right. Well, we're going to start first with credit agreements because of the National Credit Act, because of your whole life being linked to credit in one form or another, even if you loan from your wife or whatever the situation is. We're going to talk about that, loans on the family. But credit agreements, I personally think, is one of the agreements, if not the agreement, that is used the most in the world. I mean, if you think about it, banks, credit cards, and all of those things, they come together under the National Credit Act in South Africa as well as globally. So let's have a look at it. Let's talk a little bit about credit agreements, a couple of court cases, and then this is where this webinar for me is the best. We give you a practical template, and in that template, you must just take out what you don't want and put in what you want, and we give you a template for every specific agreement we do here. All right, obviously the NCA was introduced, the NCA being the National Credit Act, to promote and advance the social and economic welfare of South Africans, promote a fair, transparent, competitive, sustainable, responsible, efficient, effective, and accessible credit market and industry, and to protect the consumers. So that's a mouthful. That is then the whole goal behind the National Credit Act. But if you have to draft a credit agreement, what is a credit agreement? We need to tell you this because how else are you going to lay the minimum foundation for drafting such a contract? And I have drafted hundreds of them, electronic credit agreements, normal written ones. I don't know how many of these contracts I was asked to draft under the National Credit Act, outside the National Credit Act, but that can also be done. And of course, we are going to be looking at the relationship between the Consumer Protection Act and the National Credit Act, because there is a lot of confusion about that. And we will alleviate that confusion today here. A credit agreement can be defined as an agreement between a credit provider and a consumer in which the credit provider supplies goods or services or lends money to the consumer. And just there, make a note. This sentence, the credit provider supplies goods or service or lends money to the consumer. That is the National Credit Act and the Consumer Protection Act. Now, if we were to buy the goods and services in the form of a motor vehicle on credit from Nedbank, which act will apply? It will be the National Credit Act as well as the Consumer Protection Act. The National Credit Act will control the money lending. The Consumer Protection Act will control the motor vehicle. All right, going to give you a second or two to think about that. Is that all? Is that all I can say about it? What do you think, Lisa Fourie? Do you think that's all I can say about it? No, not by a far stretch. The service rendered by the bank in lending you the money, not the lending of the money specifically, the service they render to you, that also falls under the Consumer Protection Act. And that is why I love law. Isn't it interesting? I really get excited about this stuff. And that is how the Consumer Protection Act and the National Credit Act works together. So even if you only do a personal loan and there is no goods involved, what is involved? Services. And if there's a lacking of those services under the Consumer Protection Act, you can address it. If there's a problem with the learning, maybe the interest rate is not right or there's something unlawful, then you will do it under the National Credit Act, but both acts apply to the agreement. So what I've actually just said, it means that a National Credit Act cannot survive without a Consumer Protection Act, but a Consumer Protection Act can definitely survive without the National Credit Act if I buy the vehicle for cash. All right. I don't think you'll ever have a problem understanding that ever again. So there, under that heading, they says the following: the consumer pays for the goods and services or repays the money so borrowed in installments over a period of time, or where the consumer is to make a single payment. This payment is on a future date agreed upon by the consumer and a credit provider, and the consumer has to pay interest, fees, or charges on the outstanding balance of the money borrowed or the amount owing on the goods and services supplied by the credit provider in terms of all the above. If there is no interest, fees or charges, this cannot be a National Credit Act. Please make a note there. So that is on the above. All the above payments, the 2 pointers there, it has to be either interest, either fees or charges, or all of them. Furthermore, the consumer and the credit provider enter into bond transactions. That's another one. Discount transaction, installment sale agreement, mortgage agreement, or a lease agreement. The credit provider provides into a credit guarantee agreement with one person, where this person promised to pay a debt incurred by another consumer upon receiving a demand from a credit provider. And then we have answered the question, what is a credit agreement? Now, when you draft, you have to decide where it falls, because each one of this in the Act, in the regulations promulgated to the Act, is fully discussed. So, to summarize in short, what is a credit agreement? It's an agreement in terms of which credit provider sells goods or lends money to a consumer. Sell goods, remember, must be on credit, because it's a credit provider, so that's fine. The consumer is expected to agree to the terms and sign the agreement. The agreement will contain information about a credit product that a consumer has applied for and being granted, and I want to say in there, on credit. This information should include questions such as the repayment period, insurance, interest, and other fees charged, and what will happen if the consumer fails to pay his installments. And that's just a shortened summary of a credit agreement. There you have development agreements. Now, first of all, your credit agreement, you can make a note there, is always very long. If you draft a credit agreement on National Credit Act, it's just 2 or 3 pages long. Yeah, I don't know if that's possible. I've never been able to do that. Now we go on to what is another credit agreement, the development credit agreement. They are usually very cheap in terms of interest. Have a look if you can spot why. A special type of credit is created and defined in the National Credit Act. In terms of the Act, there are 3 types of development agreements. Loans for educational purposes, so they loan interest is due to education. Loans to build, expand, or improve low-costing housing, then of course it's low-costing housing. And loans to set up small and medium-sized businesses to develop thus entrepreneurs to a certain extent. So development credit agreement, go and look at the brackets. You'll see there the caps are much lower than normal. And then very interesting, incidental credit. Now before I read what I'm saying there, I want to plant seed in your mind. What does it mean when we say incidental credit? It means basically only one thing. It was never intended to be a credit agreement under the National Credit Act, but due to something happening, it became an incidental credit agreement. So let's see how I did. When an original agreement for the sale of goods and services entered into between any supplier and consumer, the intention is not to extend credit to the consumer. In other words, it's not a credit agreement, but due to the consumer's failure to pay for the goods or service on before a determined date, a fee, a charge, or interest is added to the amount due. So something happened, then it was added, and then it became an agreement. It was never the intent. So it will never fall under the National Credit Act for any purposes, except if this incident occurred and then something happens. The agreement is now referred to as an incidental credit agreement. An example of an incidental credit would be overdue municipal account or an overdue doctor's account. Which agreements are not covered by the Act? You have to know this, because you cannot go and draft a contract and you cite the National Credit Act and it falls within the ambit of the National Credit Act. I've seen this before, and actually that specific type of agreement does not fall within the National Credit Act. Can you imagine the embarrassment you're going to find yourself in? No, Mr. Lebalu, Moses Lebalu, we don't want to do that. We want to make certain from the beginning we are right with everything. So let's look at the few that doesn't belong under the Act. Agreements where the credit provider and customer are related. For example, where a husband lends money to his wife. Yeah, I don't know. My wallet is always empty, and I know I've put a few hundred in there. I don't know. I think I must put a little slip in that. So if you take that money, you've got to repay it with 2% interest and see if the money in my wallet, in my household, disappears. I think I'm going to try and do that. Agreements where members of a stokvel borrows money from a stokvel. What is a stokvel? Stokvel meaning a formal or informal rotating financial scheme with entertainment, social, economic functions, which I like also to put in there. Guys, you can write their cultural functions, which consist of 2 or more persons in a voluntary association, each of whom has pledged mutual support to the others towards the attainment of specific objectives. Establish a continuous pool of capital by raising funds by means of subscription of members. grants credit to and on behalf of members, provides for members to share in profits from and to nominate management of the scheme, and relies on self-imposed regulation to protect the interests of its members. So just to show you what the stokvel is, we get it a lot under the indigenous law, where the chiefs and those people, they will have stokvels, and that is to promote their tribes or whatever the situation is. And people go and work, but they will always contribute there. That's why I want to throw culture also in there. Agreements where the director of a company lends money to his company, there you have something like that. And agreements where a government institution lends or borrows money from any source. For example, if a bank borrows money from the South African Reserve Bank, the transaction is not covered by the Act. So when you draft, you have to know these things. If you don't know it, you can get into serious trouble and be embarrassed. All right. Now, when you draft a credit agreement under the National Credit Act, there is a couple of things that is essential. First of all, there must be a pre-agreement and there must be a quotation. Now, usually what you will do is you will send out a quotation first, and then if they like the quotation, they indicate the fact of the quotation, then you'll say, well, here's a pre-agreement, look at the terms, and come back to us, tell us whether you're happy with this, and then you will merge into the official agreement. But I found another way that is legal to do it. I incorporate my pre-agreement and agreement, and I set up one agreement, and then I have just different time frames at the end they sign it. And the first time they sign it, listen to this, guys, I built a clause in there, you're signing this now for the purpose of the pre-agreement. And then when they sign it at a later date, then obviously they sign it as a full agreement. And you know who taught me that? Sanlam. Sanlam used to combine them. So I don't know if they do it still, but they used to combine it. So there is a technical loophole there. And it has to do with the consumer indicating that he's signing the same agreement. Now he's signing as a pre-agreement. And then a day or two later, he's signing as an official agreement. So, but it's tricky. You must really, you must be careful in terms of how you draft that. But certainly, you know how to do it. I'm teaching you a dangerous thing now. So please, if you're a beginner with the drafting of contracts, don't attempt this. Except if you can get an example or something like that, or a template that can show you how to do that. But of course, that saves a lot of time. Every time you have to sign for a bond in a house, I hate it, because you have to sit there and everybody in the city knows who I am. So the attorneys, if I walk in, they actually force me to read every page, and you deal it 3-4 hours. Pre-agreement statements and quotes. The Act requires that the consumer must be given a pre-agreement statement, a quotation, before entering into a credit agreement with the credit provider. So that has to happen before time. Now you will see that the Act gives you templates. So when you draft, you can go and look at a quotation templates. And remember that the quote has to be signed. Make a note there if it's not in here. That quotation has to be signed, being indicative of the fact that they are satisfied with what you have quoted for. It doesn't help to say they write an email, although email can be electronic signature also used now, but maybe they phone you and they tell you, and there's no proof to that effect, and later on you've drafted everything, and they back up by saying, but I never did it. If it's an email, hey, we've just seen it. We can use electronic signature as confirmation of that. But they have to sign that quote. That's the right way of doing it. A pre-agreement statement documents details the terms and conditions of the agreement, and a credit provider intends entering with the consumer. In addition to consumer be giving a quotation disclosing the cost of the credit required, the quotation must include a principal debt. This is important. You are drafting now. You are drafting. Look at this. This quotation must include a principal debt, the interest rate, the total amount payable under the agreement, the installments, and all fees, charges, and interest. If it's not in there, as the drafter, you've not done your work. So that is very, very important, all right? The pre-agreement statement, statement and a quotation can either be written in one document or in separate documents. Actually, we build it in there. That is for the pre-statement and a quotation. What we do is we give the quotation. My advice to clients is send a quotation out. If they approve the quotation now, send them the terms and conditions and the pre-agreement, but it remains one document. It's going to have 2 independent divisional signatures on it, all right? Or you can send them all out. There's nothing wrong with that. But let me warn you about something. On the cross-examination, listen, guys, what I'm going to teach you now. This has happened in the past and it's dangerous. So you send this to a client and he can drop you into trouble. How can he drop you into trouble? You send him the quotation, pre-agreement, and the main agreement. He receives it, and he signs them within 3 minutes. Is that possible? Is that possible? He signs it in 3 minutes, or he signs them on the same day, whatever the situation is. And later on, that can be an argument that it was never brought under his attention because the obligation is on me and you to bring things under his attention. This is how we're doing. But logic dictates that you cannot sign and read all these things in 3 to 4 minutes. Now, luckily, we are saved a little bit in terms of electronic contracting, because when he ticks those buttons, he's actually saying, I've gone through it. So the onus shifts there. But if I give him a contract in paper and writing, that's impossible. There's no way, except if he went through the documents, he just kept on signing and he never read. And he was sitting in front of me. Because remember, when you electronically contract, it's totally different when you're sitting in front of me. Then there's an onus on me to go through everything with you. And that is the difference. Please remember that. The pre-agreement statement, the quotation can either be written in one document or separate documents. The quotation that consumer receives is valid for 5 business days. If the credit provider enters to a credit agreement with the consumer within these 5 days, she is obliged to do so at the same rate or cost as noted in the quotation, so they cannot change that. All right. Pre-agreement statement, meaning a statement that a credit provider gives to a consumer before entering into a credit agreement with the consumer. The statement contains the terms and conditions of the intended credit agreement. So that is stuff you have to know. And you can also remember, when you draft a contract, part of your job is to also educate your client what he can do and what he cannot do. All right, what about unlawful agreements? The Act declares the following credit agreements as unlawful. Let's quickly go through them so that we can go to the template where we can get you drafting. Agreements where the consumer is a minor, was not assisted by a guardian at the time the agreement was signed by the consumer. If the consumer misleads the credit provider into believing that he or she is no longer a minor, then the agreement will be enforceable. Agreements entered with consumer has been declared mentally unfit. That's logical. Agreements entered with consumer subject to an administration order, and that administrator did not consent. And then, of course, negative option marketing. You cannot engage in negative option marketing. I'm just going to give you an example quickly. A good example is years ago, when you had the credit card, they'll send you a message on your cell phone. We're going to increase your credit limit with 10,000 Rand. And if you do not reply to this message, then we're increasing it. We're accepting as consent. That, in short, is negative option marketing. You can go through that further. Agreements where the credit provider is not registered. And that's also something that you have to look at, and with the requirements that is important there. Right, what about the consequences of unlawful agreements? If a credit agreement is declared unlawful by a court, the credit provider cannot sue the consumer for any monies owing under that agreement. Do you remember that? That was tough. When I read it the first time, I thought, oh boy, this is punitive, so unconstitutional and punitive in its application. How can this be? The Act provides that a credit provider must refund the consumer any monies paid together with interest at the rate quoted in the agreement. So he can't get his money back. He's going to pay all these things back. It was draconic. Where it is found that a consumer will be unfairly enriched, if all the monies paid to the credit provider are refunded to him, such money will be forfeited by the credit provider to the state. Did you see this? This was Section 89. And in the beginning, it was applied like this. And then eventually in 2012, there was other court cases too, but the National Credit Regulators versus Opperman and others in 2012, they came and they fixed it. And what basically happened was that this person loaned money. He was not registered with the NCR, Opperman. He loaned money out, a big amount, 7 million and so on. He did not have to be registered also, but well, he mistakenly believed he did not have to be registered, but I'd rather put it like that. That's more correct. And at the end of the day, there was a default. They couldn't pay back. And because he was not registered, he was subject to this draconic enforcement under Section 89. And then he retaliated, and they come and they said, in terms of Section 25(1) of the Constitution, let's scroll down to it. Here it is. I'm going to read this part to you. And this is very important. I want you to look at it, because we always say this is impossible. How can they be so strict? And in the Constitution, Section 89, measured against it, was actually totally illegally. And the courts didn't see it for a while until this application was formally brought. And another thing about that court case that was also unpleasant, but they couldn't do it in another way, is the court case couldn't go back in time and correct the unfairness under Section 89 that did transpire under this draconic unconstitutional approach. Because the one thing everybody shouted was what? Unfair enrichment. Unfair enrichment. I cannot even get the basic capital of my money back that I loaned to him, even if I'm forced to walk away from the interest and whatever the situation might be. All right, so on page 17, in this specific court case, the High Court held that Section 89.5c was contrary to Section 25.1 of the Constitution, as it permitted arbitrary deprivation of property by denying the credit provider any claim against the consumer for the repayment of the money without leaving courts with a discretion to decide other words. And there you have it. 25.1. And 25.1 is also very important if you look and you go and look at the argument in a country about land reform. It is Section 25.1 that has to be changed for things to go in that direction. So 25.1, it's precisely the same. Whether it's land reform or in terms of the National Credit Act, in this case, it's the same thing. It says 25.1 of the Constitution, as it permitted arbitrary deprivation of property by denying the credit provider, whatever the case might be, in terms of what we see in front of this. Amongst others, the Constitutional Court found as follows. Let's have a look at the verdict. Like the High Court, the majority of the court held that a provision resulting in arbitrary deprivation of property in breach of Section 25.1 of the Constitution. Further, the deprivation was not a reasonable and justifiable limitation of the right. Come on, guys. Come on, out of your head. All those senior colleagues of mine. What do you hear there? Section 36 of Chapter 2 of the Bill of Rights in the Constitution. The limitation clause, the general limitation clause. That's what I did there. And furthermore, let's think back, if I'm not mistaken, we are also looking at the formula they're applying there is versus Makwanyane. I think it was 1995 or 1996 in that case, where they set out a formula to have to be followed in terms of Section 36 of the General Limitation Clause, Chapter 2 of the Bill of Rights. And when I read that sentence there, reasonable and justified limitation of the right, I know they applied 36 and S versus Makwanyane. Out of the top of your head, we've been legal practitioners for years. Some of these things we know out of our head. The provision compelled the court to declare an agreement such as the one in this matter void, and order that unregistered credit provider's right to restitution be cancelled or forfeited to the state with no discretion to keep the restitution claim intact. Removing the unregistered credit provider's restitution claim deprived him of property, the court held. Further, the court held that the reason provided for such deprivation was insufficient, and the means used to achieve the purpose for a provision disproportionate. The means, Section 36, am I right? Those 5 questions. That formula under S versus Makwanyane, we have to work for. There it is. There you see it. Of course, look how excited I get about law. Do you still get so excited about law? Guys, you must enjoy what you do. The downside, if you don't, is you'll die. It will kill you for a heart attack or something. Right, let's go on. Too much about that, right? According to the court, the person claiming compensation of money lent as a result of an unlawful agreement could not do so under such agreement and must make use of an action based of unjustified enrichment. In terms of the par delictum rule, in order to be successful, the party who claims on the basis of unjust enrichments must show that he has not acted dishonorably. In that you must underline. But all right, okay, guys. What does par delictum rule means? Who wants to take a shot at that? Leslie, Jennifer Leslie, do you know what that means? It means the following. Neither can obtain affirmative relief from the court, since both are at equal fault or of equal guilt. They will remain in the same situation they were in prior to the commencement of the action, and that's what the par delictum rule means. Just for the newcomers there, I'm sure all the old guys, the senior colleagues, and even the corporate directors listening to us, they will know what that means. It's a very well-known rule. A credit agreement entered into by an unregistered credit provider unaware of the requirement to register, such as the first respondent, was a good example of an unlawful credit agreement where the credit provider did not act dishonorably. So, you know, he wasn't malicious He didn't have hidden agendas or anything like that. It's not the first time I've seen it. There was other few cases I was involved on. A guy sold his farm for 2 million rand on credit, and he was in the same trouble. Same thing happened there. The court held that if the interpretation of Section 95C of the NCA was correct, that provides that the rights of the credit provider under agreement to recover money paid or goods delivered to consumer must either be cancelled or forfeited to the state if the consumer would be unjustly enriched regardless of turpitude or other factors relevant in a fairness or public policy inquiry. And you can see that in paragraph 18 of the Opperman case. The section differs significantly from common law by taking away a credit provider's right to restitution. And then they went on there and they said, furthermore, in terms of the effect, let's rather read it, of the judgment court held that the order of invalidity would not have any effect on cases already finalized, so they cannot go back in time. Further, the common law position regarding unlawful contracts will prevail until the legislature replaces Section 895C. I will say something about that now. The unlawful agreement would be void, and a credit provider would be able to claim successfully from the consumer on the basis of unjustified enrichment if the requirements of the action are met. And since that court case, all the cases we've done like this has rolled out like that, but not specifically on legislation. That was just amended shortly, a few years ago. This could include a consideration of circumstances of each case and especially the degree of blameworthiness of the unregistered credit provider in order to reach a just outcome. The court held at paragraph 85 of the Opperman case. The appeal was dismissed and the order of constitutional invalidity was therefore confirmed. And then they ordered, the applicant was ordered to pay the first respondent's cost. Now, there's two things I want to say here before I move on. When they tell the parliament or whoever's responsible, the certain committees in parliament to amend the law, and of course the National Credit Regulator being the forerunner there, what do you use since this date to fight your case? The case precedent, the Opperman case. And since then, there's been more cases. This is what you use until the law's amended. So now you have a remedy. The second thing I want to make mention of is I was surprised about the cost being paid. They say that the first respondent must pay the cost. I'll tell you why I was surprised at that. I find it strange that where the first respondent was only following the act. He wasn't malicious. I cannot see that as malicious. The act was on his side. And clearly they said it was unconstitutional. So that to me was a little bit troublesome, and the first respondent has to pay the cost, except if it was based on the supposition that it was due to him appealing the High Court verdict that already told him the situation. But then on the other hand, you know, I don't totally agree still with cost, because remember, you cannot have a Supreme Court of Appeal and a High Court confirm a constitutional ruling. They make the order, but the appeal court still had to send this upstairs to the Constitutional Court before it had executive power, if indeed the Constitutional Court accepted it. Now, that's just me. That's my opinion. You don't have to worry about it. That's the way I feel about it, except if there's something in the court documents I didn't read. But I thought, you know, that I would have rather did something else about cost there, because clearly the legislator in this case acted unconstitutionally. But that's how my brain operates. All right. Let's go on there to unlawful provision clauses and credit agreements. We are slowly starting to come to the end of this. The Act does not allow certain provisions. Now remember, we previously dealt with unlawful credit agreements. All right. We're now going to deal with clauses. Now, if you're going to the beginning of your guide on a chapter where we gave you the template, you would recall we spoke about a clause, severability clause, the severability clause, severability clause. And that is where you can cut stuff away. So this is what we're talking about. Certain clauses in a credit agreement you cannot draft in there because they will be unlawful. Let's quickly have a look at those. Clauses which misleads the consumer subject to potential fraud. Waiving his rights that might apply to a credit agreement. The rights that cannot be waived include consumer's right to have debt restructured, the right to have repos goods sold at a fair market related price, and the right to dispute any debits that pass through a consumer's account. I want to show you something. You guys know that auctions fall under the Consumer Protection Act. Did you just read what we stated there? the right to have repossessed goods sold at a fair market-related price. Auctioneers used to get away with it. They take your car, it's worth 100,000 rand, they sell it for 10,000 rand, and he and his buddy is very happy. That has to do with the Consumer Protection Act, the promulgated regulations on auctions there, and you must go and look at that. So this is also something there that's very important that we have to take cognizance of. A further one day, consumer to acknowledge that he has received goods, but I've never received the goods. He says he acknowledges, but he has never. Forfeit money is paid to the credit provider in the event of consumer terminating agreement, cannot do that. And then, of course, leaving your ID book, which in any event, by the way, what does the law say about your ID books? Does it belong to you, to the state? Your ID book is the property of the government. They can take it away if they want to. They can put a block on it. There's a lot of things they can do. Bank cards, PIN numbers, not allowed to take that. Interesting about identity documents, you can actually get in trouble if you maliciously damage it, strictly speaking. So that is an interesting thing I'm telling you now, that you know that. Right, clauses that authorize the credit provider to do a set-off, except if the credit either has agreed to a specifically agreed upon set-off. So the terminology around that set-off must be 100% right. Then very important, the following common law rights or remedies that are available to the consumer may not be waived in credit agreements. Let's have a look at it. Exceptio errori calculi refers to defense based on an error in calculation. Exceptio non numerate pesunio refers to defense by a party who was sued on a promise to repay money that was never received. And exceptio non causa debeti refers to defense that the debt claimed has no basis or ground. And you cannot take that away from a consumer. Also, those remedies you cannot write out. And furthermore, the exceptions referred to above as the effect that a credit provider need not prove the substance of the relevant exceptions in detail when a credit agreement is being enforced. And the other party will then, of course, come and have to submit the necessary evidence if they're going to oppose it. Consequences of unlawful provisions of credit agreements. Let's have a look at it. Please now, when I read this, take into regard the Opperman case. A consumer cannot be sued or forced to comply with a provision in a credit agreement which is found to be unlawful. There you go. Unlawful provisions affect credit agreements in two ways. Unlawful provision may cause the entire credit agreement to be unlawful, and the consumer cannot be forced to pay the credit provider under that agreement. Now, take into regard Opperman case. That's very important. You cannot read that specific sentence in isolation. And then, of course, the last one, an unlawful provision can be amended by the court or deleted to ensure the agreement remains lawful, in which the case the consumer will still be bound by the credit agreement and the amended provision. And I must admit, that is important for me there. Now, I need to say something here that's very important. And I think I said it in the beginning. You cannot cut a clause out of an agreement if it's going to negatively impact on the totality of the contract. Defeat the very purpose for which the contract has been set up. You cannot do that. Then the court will go and say, sorry, the whole agreement is then rather void than us cutting out a clause that goes to the essence of the reason the agreement was set up. So you must also understand that when you draft. Remember, when you draft, you would say, but why are you teaching us on a contract law all of these things? Well, the first thing that comes to mind is mitigation of risk. You need to know these things, that in the manner you draft, you can mitigate the risk to be legal, and also to know where you can go, and also be cautious of not overkilling your contract. Because if you put a lot of unlawful provisions in there, you're going to have a problem with legality, but you're going to also move into the vicinity of overkilling. Nobody will sign it. And if it's signed later on, somebody is going to incur some sort of damages, and you might also get sued for negligence as a legal practitioner. Now, that is a dangerous situation. It's out. I've said it now. So you need to know what you're doing when you are providing this service. All right, guys, we're going to go on there on page 20. Changes to credit agreements and decreases of credit limits. The Act states that any change that is made to a credit agreement which the consumer has already signed will have no effect unless the change reduces the consumer's debt under the agreement, the consumer signs here initials in the margins next to the change made, or the change is recorded in writing and signed by both the consumer and the credit provider. If the change is agreed upon orally, it must be recorded and thereafter reduced in writing. And you can convert this into clauses. You can build this and say, this is how it will, if we have a variation, if we have an amendment, this is how we will deal with it. This becomes your drafting skill and the information that has to go in there under. In terms of the Act, the consumer is entitled to instruct the credit provider in writing to reduce his credit limit on a credit facility. The credit provider must confirm with the consumer that the limit was reduced in accordance with the consumer's request and must indicate a date when the reduced limit becomes effective. So there, you can utilize that in a clause 2. It's educational if you draft it into the agreement. A consumer is allowed to request the credit provider to increase his credit limit on the credit facility either temporarily or permanently. The consumer has to agree in writing to an automatic limit increase to his credit facility. But even where the credit provider obtains such agreement from the consumer, the limit may only increase once a year. So please take note of that. That's what the law says. However, consumer may at any time request an increase of the credit limit. That is from his side, he himself. All right. Very important in the drafting skills, you have to know the following. Amongst others, the agreement within the preamble of the National Credit Act, at the very least, must adhere to the following legislative requirements when you are drafting it. Obviously, it must be in writing, must be in one of the officially recognized languages, plain and understandable language, and it must be signed by all the parties to the agreement. There's the Consumer Protection Act, but I already spoke about it. There's the POPIA, the Protection of Personal Information Act, and we are going to have to deal with this. We cannot go on without dealing with that, because when you deal with a credit agreement, you have a credit application and you're going through all these vetting and assessing procedures, and you are privy to very personal information. So let's see what is happening here. And in your agreement, you have to talk about the fact that you will adhere to the requirements as set out on the POPIA. This is imperative. You cannot move away from this, and you can actually be sued. There can be really serious consequences if some of this information gets out and to the negativity of the other entity, whether it be a juristic or natural person. Please take cognizance of what I'm saying. Natural persons got rights. LSSA Bank as a juristic person also have rights. Please don't think for a second that if you defamate commit defamation, not defamate, but commit defamation against LSSA Bank, they can sue you if there's no grounds for it, and if they want to do it. A lot of people don't know this. Personal information means any information an identifiable person according to POPIA. Does personal information that belongs to a person is not generally available or known to others according to the NCA. So it's important to understand that it is information that's not in the public forum. And if you have publicized your information on Facebook or those places, you cannot come and attack somebody else when it's leaked. Because if it's out there, it's out there. So be careful of that. If they can prove, but no, this was in the public domain already, then they have a defense. Consumer credit information, specifically under the National Credit Act, means the following. A person's credit history, including applications for credit agreements to which a person has been party, pattern of payment or default under such credit agreements, debt rearrangement in terms of the Act, incidents of enforcement action with respect to any such credit agreements, the circumstance of termination of any such credit agreement, and related matters. That paragraph there can seriously amount to defamation if leaked. Further, we have a person's financial history, including past and current income, assets, debts, matters in the scope of person's financial means, prospects, obligations, and so on. Person's education, employment, career, professional, business history, and they go on there. You can read that in your own time. A person's identity, including a person's name, date of birth. And the one that's important to me, let me not go too fast. I just want to have a look at something. Marital status and family relation, past and current addresses, and other contact details and related matters. Contact details. Do you see contact details? Be careful what you do with your email information, all right? And then, of course, then that last paragraph, a person's identity, we can also talk about identity theft if this were to be leaked or whatever that situation then would be. So this is the things you have to think of when you draft things into contract, and you have this information at your availability, and then of course you have to inform people about their rights accordingly. POPIA is the comprehensive data protection legislation in South Africa, and it aims to give effect to the constitutional right to privacy, whilst balancing this against competing rights and interests, particularly the right of access to information, and that comes down constitutionally to the balancing of rights. And we'll see if we have time left. I could tell you about a court case there that very well explains the balancing of rights to you, where you've got two rights competing and the court has to decide which one is more important than the other one. So in POPIA, what does personal information mean? Remember, we looked at it from a perspective of the National Credit Act now, and they say under POPIA itself, it means the following: information relating to an identifiable living natural person, and where it is applicable, identifiable existing juristic person, including but not limited to the, and then they go on there. Information relating to the race, gender, sex, pregnancy, marital status, national, ethnic or social origin, and it's basically the same as Section 9 of the Constitution under equality. Furthermore, information relating to education, we already said that. We said identifying numbers, symbols, and there you have it. Look there, email address, physical address, telephone number, location information. That's why when a telephone book comes out, you must say, you can make my telephone public or you cannot. And the one that's concerning to me, there's the email addresses. So that's interesting. That's deemed as personal information. The biometric information of a person, biometric information meaning a technique of personal identification that is based on a physical, psychological, behavioral characterization, including blood typing, fingerprinting, DNA analysis, retinal scanning, and voice recognitions. I'm just quickly thinking about firearm applications, amongst other, in terms of fingerprinting there, and so on. So that is biometric information. A person's opinions, etc., etc. Correspondence sent by a person that's explicitly of a private or confidential nature. The views or opinions of another person. The name of the person if it appears with other personal information relating to the person, or if the disclosure of the name itself would reveal information about the person. Now, strictly speaking, this is so strict, I cannot believe that some people take this with a pinch of salt. And we've already done a lot of cases on it, and we've already seen a lot of people getting sued on it. And ladies and gentlemen, that's it. What we're going to do now, if we're going to go into the drafting of the credit agreement, I just want to take a bit of water here for my throat. I'm like a rally car going through this to get it into the time zones. And so on, so you can let it sink in. Let it sink in, everything we are saying here. I got to tell you guys, really, I love my job. I love drafting. And I always get excited when I talk about these things. All right, are you ready? Are we going to draft? Are you ready to draft? Let's have a look at it. Let's have a look at it. Would we, Monica Korf? Let's draft. Now, the first thing in a credit agreement is obviously your heading. And if it's an electronic contract, you can expand on your heading. Like, for example, digital channel loan. So when we look at a heading with contracts, we are going to have a heading, we can have a subheading. What I usually do with my credit agreements is I would say a credit agreement, I would call what type it is, and I will say in terms of section so-and-so, read with regulation so-and-so of the National Credit Act, and I will specifically show in the heading where I'm coming with my heading. Now, you'd find that interesting. For those who's been with me on the basic drafting course, they would know why. I don't mind to get meeting of the minds, consensus going in a contract already in the heading. People turn on later and say, I don't know what I was signing. We say, but hey, look at that contract. It's in bold, underlined, and it's 3 lines long. You got to do what you want to do. That's how I do it. In the heading of a contract, I establish full consensus already of what this is. Even if it's a green apple, not a red apple, sometimes I go beyond what is possibly necessary, but I make certain in the heading we have already consensus on what we are doing here. Full description of the parties in all capacities. This can be very complicated for juristic persons. Really, in the basic one, we deal with that. A recording pertaining to language inclusive of confirming that agreement was read to the consumer and that she was given an opportunity to ask questions about it. You see, there must be a certificate. I build those things in, you go through it. The fully detailed cost of credit in respect of this agreement is required by regulation so and so, being inclusive of the following: loan amount and disbursement of the loan, annual interest rate, monthly installment, interest, fees, charges, total cost, and interest rate. You have to do that. Specific terms. Now, when I say specific terms, most of the time this will pertain to meeting the requirements of your requirements and definition of that unique contract. Now, please remember, the definition of a national credit agreement is not the same than a credit agreement under common law because of the legislation. Their requirements is much more severe. And under the common law, they are not that severe. So both is a credit agreement, one under the Act, one are not, and their definitions and their requirements differ. So if you draft it, you have to take due cognizance of that fact. Specific terms, very short, pertaining to the first installment, installment day, then the month, installment amount changes, full asset value versus replacement value for insurance purposes, cost of registration payable of the loan, debit order, instructions, and so on. And there you will look at interpretation, for example, prime rate factor, and of course interest rate. There's your mutual loan intention. That's your preamble. We'll say, what are we doing here and what is the intention? Again, you will talk in a clause form about your interest rate. Calculation and payment of interest, you've got to talk about it. You've got to show it. Property insurance, you've got to show it, how it operates, where it comes from, who, what, in-house, out-house. Property assessment and inspections, how will this operate under this situation, under a lease agreement, if this is a National Credit Act agreement? Do you see how far we're going under the National Credit Act? Improvements, for example, gas installation, compliance, rates and taxes if it's applicable, title deeds and letting of property. And already, as I'm saying this to you, can you feel it? Can you feel it? Walter Gianni, can you feel it? How your annexure clause is growing. And a short summary of every one of these attachments if it's relevant. There's a section of rentals and revenues. Special conditions, for example, advancing part of the loan that has been repaid if it's a product like that. The restriction on a session, that happens a lot. People say, well, I want a session, but this is how I want to do it. Termination of special facility, loan option or concession. Prepayment, early settlement, allocation of payments. Notice of changes and statements, like we've already said. We mentioned a few of those things. Addresses for notice. Guys, make a note for addresses of notice. A lot of the clauses says, I've used this in court cases with success before. They give an address and later you look for them, they're gone, they've disappeared. Where can you find it? If you can look at the Ambler's Harms, you'll see they teach you how to do citations and they talk about a registrated address, a registration address of a business. So if they've run away, where do you get that address? At CIPC. And the Companies Act say that they must change a business in operation, a company must change their address with CIPC. So there's an address, you can use it if you have to trace them and if they are runaways. But addresses for notice, and remember on the addresses for notice, we do it on a basic drafting. There's not only the addresses, there's a lot of stuff that has to go in there. What happens when there's default by the client? You have to be very clear on that. You have to be very clear on that, and it cannot be contradicted to the Act and regulations. Application for debt review, you're going to set all those things out. If you know how to write a section 129 letter, a 130 letter, you'll know what to, you just have to change it into a clause form, but then you'll know what to do there. Required procedure before debt enforcers, that's a 129, 130 letter. Credit bureau information, rights of the clients, you have to shorten them, but you have to put in the, you don't have to copy them out of the Act. You can just put it in a shortened version, but it must make sense, must be in there. That certificate of indebtedness, but remember what we said about your free remedies, calculi, pecunia, and all of those things. So you can have a certificate of debtors clause in there, but if the opposition can on the remedies prove there was an error or something, they can run with it. Mortgage bonds and registration costs, talk about that if that's relevant. If you're buying a house, something like that. Fees, costs, and charges pertaining to the agreement itself. And the cancellation of bonds. Guys, make a note there. Talk about the when a house is sold and you're cancelling the bond cancellation of that. That's important. And also tell them how much time they have to inform the bank they're going to sell their house, because then the cancellation, those bond cancellation fees does not have to be paid. Yeah. If you have seen, especially elder people, get so upset about this. Common law clauses, what is that? Common law clauses are all your boilerplate clauses, and we've listed them for you in that first chapter there. I'm going to page back to you. You just stay there. So that's whole agreement, variation, relaxation of terms, jurisdiction of magistrates court, address for service, legal cost for drafting of contract, legal cost for litigation, alternative dispute resolution, negotiation, mediation, arbitration, breach, governing law, joint and several liability, severability, confidentiality, execution of contract, counterparts, annexures. So those are your boilerplate, your common law. And now I ask you a question. How long is this contract? How long is this contract? 2-3 pages? I tell you, it's impossible. If you do it under the National Credit Act in that length, it cannot be readable. It's too small. And that's also an issue. You have to use the right font that's readable to people. And then, of course, you end with date, place, and signature, and full detailed signatures in all capacities. Please underline. All capacities. I cannot overemphasize all capacities because you're a natural person, but are you a trustee? Are you a liquidator? That too. I saw that yesterday. I did something on that. The permission for a liquidator then to act on behalf of the company as liquidated. He needs permission for that. Are you a director? What is your capacity? And then, of course, you will end your signature with what? What do you think you will end your signature with, Bianca Westhuizen? Yeah, that's right. You'll end off with duly authorized to sign on behalf, something like that there. And ladies and gentlemen, that's the 2 hours for today. I'll be back tomorrow, and then I will see you guys again later on. And that's a week or 2 weeks from now. It's there on the 9th. So I suppose then I'll see you next week on those 2 dates that's booked for this. And that's about the size of that. Okay, guys, I hope you had fun. I hope you understand credit agreements a little bit better, and I hope that you have a template now. Because I'm telling you now, if you follow this template, you can factor every imaginable contract you can think into this template. And that's why it's so important to attend the basic draft of contracts webinar also. And you can do it after you've done this advanced one. It is not necessary for you to say, I've done advanced ones, I'm not going to do that one. Because there we tell you about the template, the headings, what's the court cases on that. And you'll be surprised. That's also actually a high-level training in contracts, but on the basic foundation of the structure and its content. And here we just go into specific agreements. All right, guys, that means I'm out of here. Have a pleasant afternoon, and I will see you tomorrow. Be safe.